Welcome everyone to Countdown to Compliance. Sorry we're a little late. Hopefully everyone is piping in and they're getting a seat and they're ready to go. We'll be quick on the intro since we started a little late, but we are here today to talk all things SB, Senate Bill 38 for Texas. You are all a curated audience that we reached out to in the Texas population to talk what's going on in your neighborhoods and also your government. This bill has been in the works since last spring and it's come into fruition now. And we also have the experts on with Duke and Heather. And I will go ahead and jump into who our presenters are today. And first up, we have Duke. And Duke is a Texan attorney that specializes in multifamily operations and legality. So he has a long history and expertise established in this field. He's very passionate about it. And he is here today as our special guest and our honored guest to really walk us through what is going on with Senate Bill 38 and how it's going to impact you and your operators and your teams, and then also what to do to get ready for it. And then we also have from our side of the house our very own Heather Hayes. Heather is our legal director for Nationwide Compliant. She has been here almost 10 years, Heather. I believe that's right. And she's also an attorney, and you'll see in her bio, she's an attorney with a good heart that does a lot of pro bono work in her community to help others as well with multi-housing and different things in the neighborhood. So we're all about community here, and that's what we're going to talk about today. And with that, I'll let the two of you guys say hello to everyone, and then we'll get straight into it to a packed agenda.
All right. Good afternoon, everyone. A lot of you guys may know me from Nationwide Compliant. I may have handled a few cases for you guys throughout the process. We're really excited about putting on this particular webinar just because SB 38 has resulted in a huge change in eviction laws. And so I believe that it's going to be important for you guys to understand not only the analysis behind the law, but also to understand how it's going to play out on a day-to-day basis starting in 2026. So I'm excited to dive into some of these materials. I try to get you guys out as soon as well, not as soon as possible. I want to make sure that I review everything, but I will give it over to Ms. Hayes, who I've been working with for 7 years now, 6 years, I want to say, who's been excellent. So Heather, if you want to go ahead and introduce yourself as well.
Yeah, as mentioned, I'm Heather Hayes, legal director here at Nationwide. A lot of you probably email with me a lot through filing at Nationwide Compliant. That is me, and that's really the best way to reach me. I know we have a lot of questions with the new Senate bill coming out, so I'm excited to get started and see what Duke has prepared for us, and we're eager to hear your questions and get you answered.
All right. Well, thank you too. We're definitely glad to have both of you here, the experts. I'm Adam Pierce. I'm from the Inhabit marketing team, so I tried to help get this set up. But I probably will not be a lot of help other than clicking through the slides because you guys, we have the two legal counsel here, and they're going to do all the talking and question answering for us. Just a reminder, this is being recorded, and the replay will be sent out at the end. And then as well as we will have a Q&A session later, so make sure you get your questions ready. And then there will be a 5-question survey at the end of the webinar in case we missed anything for you or you have additional questions or you like to be contacted by Nationwide Compliant for further information on how we can help keep you compliant in 2026. So with that said, I'm going to go ahead and kick it off and turn it over to you, Duke.
Sounds good. All right. So I know that a lot of you guys have been hearing about this SB 38, which is the new legislation that came out earlier this year. A lot of big changes have been made in regard to evictions and the process for evictions. One of the things that we want to make sure is that we understand that these changes are going to take place starting in January of 2026, but a lot of the things are going to be left open for interpretation. So as I go over this slide with you guys, I am going to be giving you guys the interpretation that I see and I believe, but we have to remember that in Texas, there's roughly about anywhere between 800 to 900 judges that are going to be sitting on the bench starting in 2026. And so each judge is going to have their own interpretation of these particular laws. We don't have enough information just yet, or case law, in order to determine exactly how a lot of these judges are going to rule. But based upon the research that we have, that's what we're going to look into today. So I wanted to start off by just giving you guys a huge overview on some of the bigger changes that are happening that most of you guys are probably aware of. If you attended any of the Texas Apartment Association webinars or any of the other webinars, you guys probably are aware of these changes. So the biggest one is going to be coming in regard to the notice to vacate versus the notice to pay or vacate. And so that's going to be one of the biggest things that we're going to be talking about. But even with that, we have to remember that in SB, they've released more options that allow you guys to be able to deliver notices. And so the intention behind that was to ensure that whenever you're going to court and you're delivering these notices and you're getting caught up on these particular issues and getting cases dismissed, they wanted to streamline that process in order to make it easier for you guys to deliver notices. And so we'll go over those a little bit later on in the deck in a little bit more detail. That way you guys can recognize what these new options are. Change is going to be in regard to service deadlines. A lot of you guys are going to be excited about this, but a lot of the issues that we see on a day-to-day basis have to do with the timing of evictions and evictions taking too long. And so we're seeing anywhere between 20 to 60 days is the average for us to get some of these evictions turned around. And a lot of these details are outside of our control because we're relying on the constables to deliver not only the citations for the evictions, meaning the eviction paperwork, we are also relying on them to serve writs. And so if they're taking their time when it comes to these particular actions, it's delaying the process for you guys when you're trying to get these tenants out who have been sitting on non-payment of rent for 2 months. And so SB 38 has allowed faster service deadlines, and they've allowed you as well to be able to go outside of the constable's office and hire trained officers to either deliver your citations or deliver your writ of possessions as well. And so we're going to go into a lot of detail on that so that you guys can recognize when this may be a good idea to utilize this particular law whenever it comes to the service of your citations and your writ of possessions as well. A lot of the issues that we've also been seeing are in regard to squatters. So we know that squatters are a big issue in Texas, just because whenever you make a general phone call to the constable's office, if you have a squatter inside of their unit, we all hear the thing, open quote, this is a civil matter, you'll have to file an eviction. SB 38 has allowed you guys to kind of streamline this process a little bit more through a summary disposition process. And they've also introduced another bill which makes it a criminal matter for there to be squatters in the unit, but you need to ensure that you're applying the correct law on what a squatter is, because that's going to be important. If not, you're going to end up wasting money and time trying to do the summary disposition process. And the summary disposition process should always probably be done by some sort of attorney. So make sure that you guys are paying attention whenever it comes to this particular action as well. The other thing is going to be in regard to the timelines for the evictions. So again, we're dealing with anywhere between 20 to 60 days whenever it comes to these evictions, and that's just a little too long. And so a lot of the people that wrote this new legislation, they want to speed up this process, making eviction trials happen a lot quicker. And so they've always kind of been in that 21-day range, but basically the law has changed to allow you a shorter period of time from when the defendant has to be noticed. So that changed from 6 to 4 days. And so that's going to help you guys speed up the process a lot more, because what's happening is that sometimes the constables are taking too long to serve the tenants. And then if the tenants aren't served on time, then you're resulting in resets for your particular cases and your evictions. The other thing that I deal a lot with is going to be the appeal process. That's primarily what I work with Nationwide in regard to. And so SB 38 actually put in some really strict regulations when it comes to paying rent into the court registry during the appeal process. Throughout this year, the major questions that I've been getting in regard to the appeals are, why has my case went up even though we filed the writ of possession and although the tenant has failed to pay into the court registry? That question is going to be answered throughout this particular deck in regard to the new laws that are going to be updated. It does require the tenants now to pay into the court registry, but it also allows you to be able to get a writ of possession without having a hearing in the event that the tenant fails to pay rent into the court registry during the appeal. So I'll go into it in more detail, but basically it allows the process to move a lot quicker when it comes to these appeals. And last but not least, the reason why they introduced all of this legislation was because they wanted to make sure that there was a statewide consistency in regard to the way that these eviction laws roll out. So you'll see it in one of the slides that we're going to discuss, whether or not the justice of peace judges can make their own rules in court. And so SB 38 kind of limits the amount of rules that these individual judges can make, such as setting mediations, requiring resets in order to get judgment. So I'm really excited about a lot of these changes just because they're going to help us speed up the process when it comes to servicing you guys. And so I'm hoping that you guys will stick around for the entire deck. That way we can explain all of this in detail to you guys. And so with that, we'll go to the next slide.
So, Duke, would you say like the main highlights is this is designed to make the process move faster and be more consistent and more fair across the state?
Yes, yes, that's exactly what it is. And a lot of the issues that we've been seeing are that a lot of these tenants are able to get free or pro bono legal aid. And so they'll get you on small issues such as your delivery method or the way that you signed your petition, or even on the squatter cases, squatters are being able to get more rights than tenants who even are paying rent. And so they've done this in order to streamline the process. One of the slides that's not in here, and I know that everybody wants to know, is the CARES Act process. And so we're going to discuss that, but I'm going to leave that for like a 2 or 3 slides. So I want to make sure that we do that in detail as well.
Okay. Sounds great.
All right. And as we just explained, you guys, these updates aim to make the process faster and more consistent across Texas. We are tired of hearing properties lose cases based on small, simple matters, such as that delivery of that notice to vacate. And so this new SB 38, it changes the game a lot, and it makes it very fair for both sides, based on the fact that not only will you be able to deliver these new notice to vacates, but also it allows the tenants, and we've seen a good response on some of the notices. It allows the tenants to come in and pay their rent. Previously, when we were introducing just the notice to vacate, a lot of the tenants would assume that they couldn't pay their balance. With the option to deliver this new notice to pay rent or vacate, some of the tenants are now coming in and paying their entire balance because it makes it a little bit more descriptive for them on what their instructions are. And so I think that this is going to be very beneficial for Texas moving forward when it comes to eviction law. And so that's the main thing. But I also want you guys to keep in mind that we're talking about Texas law. Some of your properties, such as HUD properties, are still going to be governed by federal rules. So make sure that you're applying those rules correctly, and that any of the updates that I'm explaining to you guys are only going to be based on SB 38 and Texas law. I will dive into some of the HUD stuff a little bit, just because some of you guys may be voucher based or project based. And so we'll discuss that a little bit, but I won't dive too much into it because a lot of those regulations are still going to be in place.
All right.
All right. So let's go into the notice of vacate, which has always been here when it comes to the eviction and the way that you guys process your evictions. Previously, we all know that there were 4 methods that you could utilize when it came to delivering a notice of vacate. And a lot of those methods of deliveries are still going to stick behind on SB 38, but there are some additional ones that make it a lot easier for you to be able to deliver a notice to vacate. So we know that the primary 4 were that you could deliver it to somebody who lived in the inside of the unit who was 16 years or older. So that was the primary method that a lot of the properties have been using in Texas. The other method was that you guys had to deliver it by posting it on the inside of the main dwelling. And that's where a lot of my clients were getting caught up, is on that confusion about posting it on the inside of the main dwelling. A lot of my managers may slip it through the door. They may have placed it somewhere inside of the unit, not on the back of the door. And previous to SB 38, that would be grounds for a dismissal. And so the law, and the way that I'm going to explain it to you guys, it's going to allow you guys to be able to deliver notices by putting them pretty much anywhere in the unit to where the tenant can view it in an easy way. The other method of it was, of course, through first class, registered or certified mail. And then the last method was going to be posting it on the outside of the door, putting the words important notice along with the address, and dropping it in the mail on the same day. So those were the 4 methods that we were using prior to SB 38. So first, I'll go over the ones that are going to remain the same. A hand delivery to a resident age 16 or older, that's always going to be in place. And so I want you guys to remember that you can still deliver notices. And this is the best method when it comes to delivering notices, is by putting it on, by giving it to somebody who's 16 or older. We have to remember that when it comes to that, you want to ensure that that person actually lives in the unit. We don't want to be delivering the notice to a guest of that person who is a leaseholder or to a kid who may be under the age of 16. If you can't guess or know whether or not that person is certainly age 16, then you want to wait, come back and deliver it to the parent or use another method of delivery of that particular notice. So let's just ensure that even though this is still a law and it still allows you to be able to deliver it personally, you want to make sure that you're doing it correct, because if not, you're going to end up with a dismissal. The second one, of course, is going to be the first class registered or certified mail. Now, this has always, again, been a law in the past when it came to the property code and the delivery methods. But I want you guys moving forward, if you can, when you're delivering notices, try to send them out with some type of tracking if you're going to do it via mail. Because the issue that we have whenever we get to court is that you say, oh, I delivered it via first class mail, which is just a stamp, but you have no proof of that. So the other method is that if you want to take a photo of the actual envelope, that may work as well. But just delivering it first class is not going to work. You can still deliver that method, but it's not going to be the best method of delivery when it comes to putting these things in the mail. The best method of delivery when it comes to mail is going to be sending it out via certified mail as well as first class mail. That way, if the tenant fails to sign off on the certified mail, or if you send it via mail and they forget to go to the mailbox and pick it up, you still have that first class mail that's going to sit in their mailbox until they make a decision to pick it up. And so you can always testify to the judge like, hey, judge, I sent it out two methods. Yes, we got the certified mail back, but we didn't receive the first class mail back. And so that confirms to the judge that somehow this tenant got the notice. And it also gives you a backup method. So if you're going to be delivering it via mail, let's always remember that we want to deliver it via first class mail and some type of certified mail or registered mail that has a tracking along with it. So you can upload that to Nationwide. And whenever the agent or the attorney that's going to be in place, they can use that if the tenant says, hey, I never received the notice. So that's always been in place as well. You can also use a delivery service. So you can also use companies such as FedEx and UPS if you want to quickly get a notice over to a tenant rather than relying on snail mail, which may take 2 to 3 days. If you're going to deliver it via FedEx or UPS, you got to do the same thing where you have some type of tracking where you can prove to the judge that this notice actually got delivered. The next method is going to be what we used to know as posting it on the inside of the main dwelling. That has changed, and it allows you guys to be able to easily provide this notice inside of the unit. So the law changed when it allows you to be able to actually place it on a person's, like let's say you walk into the unit and they have a coffee table. Instead of actually posting it on the inside of the main dwelling and taping it to that entry door, as long as it's in a location that when the tenant walks into their unit, they can immediately see it, that will be a viable notice to vacate that you can use in court. So if there's a kitchen table, you can put it there. If there's a bar located on the inside of the unit whenever they walk in, you can put it there. So you can put it pretty much anywhere as long as it's not hidden inside of the unit. So obviously you don't want to go into a person's bedroom or put it inside of a stack of, books or put it underneath something, because at that point, then it would be considered to be hidden. But anywhere else where they can immediately see this particular notice is going to be allowed moving forward. And that's one of the biggest changes that SB 38 is going to be rolling out. And that's one of the biggest changes that I'm really excited about, just because a lot of the evictions that when we do lose them or whenever we have to settle them, they're typically in regard to a bad notice to vacate that was delivered incorrectly. And usually this comes through slipping it through the door or putting it on the inside of the dwelling and putting it on the coffee table. Prior, you couldn't do that, but now you can do that. And a good method whenever it comes to mail or hand delivery inside of the unit is to also take a photo. If you guys can start taking photos and uploading those photos to Nationwide, it will assist the attorneys and the agents a lot when it comes to litigating these particular evictions, just because it'll be the tenant's word against that attorney or agent. And if we have a photo, it makes it a lot easier for us. So if you guys can start taking photos and uploading those photos, that would be great. And that'll help out a lot when it comes to these particular methods of delivery. Now, the last one that I'm going to talk to you guys about is the biggest change that we have. It's going to be in regard to the method of email or other electronic methods. So the new TAA lease contract is going to put in the correct language that's going to allow you guys to be able to send the notices via email. And so as long as that person in their application fills out the email correct and you use that email, you can now deliver these notices via email. And it's just going to be important that you guys are looking out to ensure that these emails aren't bouncing, because one of the primary things that could end up hurting you is if you send that notice out via email and then it bounces and the tenant says that they never got that particular email. Because the primary thing when it comes to these evictions and what the new law has adopted is that this notice must be delivered. So receipt doesn't matter. You just have to prove that you actually delivered the notice. And that's going to help you guys out a lot. If you can send it via email and you show up to court and you're able to show the judge the email and the fact that it was sent out. But you need to make sure that if you don't have a Texas Apartment Association lease and you're using your own leases, that you put this stuff inside of your lease contract and it's in bold. The fact that you're going to be delivering notices, because both parties have to consent to receiving notices via email. And so that's going to be one of the biggest things that's going to help you guys out when it comes to delivering notices within this particular unit. And so those are the primary methods that have been changed. And we'll go over some questions later on so that you guys can ask these detailed questions that you're asking. And I'll answer them at the end of this particular slideshow. All right. So one of the most confusing things that actually came out is the usage of an NTV, which is a notice to vacate, versus a notice to pay rent or vacate. So those are going to be the two primary types of notices that we're going to be dealing with moving forward. And that's what SB 38 has changed. And so it can be confusing, but you always have to remember exactly these situations when you're delivering the notices. So when it comes to the first time non-payment of rent, or let's say that somebody is behind and they've never been behind in the past, in those instances, it's going to be mandatory for you to deliver a notice to pay rent or vacate. So we have to remember that if they previously have never been late on their rent, it's going to be mandatory. If not, your case will get dismissed. So please remember this moving forward, because I want to say that Blue Moon has already introduced, or TAA has already introduced the majority of their new notices. And so some of you guys are already starting to use them. So make sure that if you have a tenant that's within a lease contract and it's within, because I know one of the questions that's probably going to come up, I would say it's safe to say that if that person has not been late within that particular lease contract, then you're safe to deliver your NPRV. But if that person has been late in that previous lease contract, meaning let's say the lease contract started December 1st of 2024, it ends on the December 1st of 2025. If any time in between that particular lease contract, that person's been late, you want to go ahead and deliver a notice to vacate. Whenever it comes to the notice to vacate that we previously used to deliver, that's going to come in an instance where the tenant has been late previously. Then you're allowed to be able to use a notice to vacate, or you can use your notice to pay rent or vacate. It'll be optional in that instance. And then let's say that we have what we call a non-monetary, which is just a lease violation. You're always going to use a notice to vacate. You're never going to use that notice to pay rent or vacate. So make sure that in these instances that you guys are using it, and we'll go over a few hypotheticals just so that you guys understand exactly how these are going to play out on a day-to-day basis starting in 2026. So remember that first time non-payment, you're going to issue a notice to pay rent or vacate. If the person has been late at some point during that particular lease contract in the past, then you're going to deliver a notice to vacate, or you can deliver a notice to pay rent or vacate. One of the biggest things that we have to remember is that if you deliver a notice to pay rent or vacate, you need to keep all payment options open. You can't deliver a notice to pay rent or vacate and then not allow the tenant to be able to pay. If that's the case and the tenant gets to court and they say, hey, I tried to pay rent within this a given amount of time and they didn't allow it, then your case is going to get dismissed if they're able to prove that. So I know that a lot of you guys are trigger happy when it comes to closing down those portals, because that's an issue that I deal with a lot, is that tenants say, well, I tried to pay, but they had already shut down the portal. If you're gonna send out a notice to pay rent or vacate, you cannot shut down that portal during that time, and you have to allow the tenant to pay rent prior. You'll see in the TAA notice that it explains all of this, and it allows them to be able to come in and communicate with you guys in regard to how they're going to pay the rent. Now, after that given amount of time, you're optional to go ahead and lock them out or start your eviction process. So just be careful whenever it comes to that. One of the other things that I forgot to bring up on the notice issues or on the new notices is that now Saturdays, Sundays, and holidays are going to be included in your NTV timeline. The Texas Department Association lease has some I want to say that they're introducing some new information or a new clause within that lease contract that's going to kind of oversee that or supersede that, but you want to still be careful when you're counting down your notice to vacate dates and the time that you file your eviction. So for example, if you deliver a notice to vacate on Thursday and it's a 3-day notice to vacate, it's going to be Thursday, Friday, and then that optional day is going to fall on a Saturday. That's going to bump to Monday, and you can't file your eviction until Tuesday. So you want to make sure that you're being careful when it comes to those particular days and counting down those days. And so I want you guys to make sure that you're counting down your days basically correct. All right, so we're going to go over scenario one. Tenant John Doe has never been late before. On January 3rd, 2026, he comes into the office and states that he may not be able to pay his rent because he spent a little too much on Friendsgiving hosting. 10 days go by and John Doe never pays his rent. The manager delivers a notice to vacate on January 15th, 2026, but waits until February 5th, 2026 to file her eviction. Does this manager have the right to deliver a notice of vacate, or will her case get thrown out? Let me get some responses.
Yeah, they're coming in. Yeah, fast. Yeah.
They are coming in fast.
Yeah, yeah. Looks like everybody knows it'll get thrown out. Yeah.
Okay, excellent, excellent. All right, so somebody put it best, and I'm just going to refer to that person. They put trashed, which is true because this particular case is going to get dismissed because you were required to deliver a notice to pay rent or vacate because this is this tenant's first time being late. And so you don't qualify to deliver a notice to vacate to them. So in other words, this case would be dismissed and you would have to start all over. And that's going to be the biggest difference between the way that you delivered NTVs in the past and how we're going to be delivering them moving forward when it comes to counting down those days. So we have another scenario. We'll go over it in a minute. You can go to the next slide.
Okay. Scenario two. All right.
All right. So let me read this one. Landlord Michael Jackson has a lease contract from 2024 that was handwritten by him, and it states all notice delivered to tenant by landlord are considered valid notices for purposes of filing eviction. Landlord sends his tenant a notice to vacate via email on January 6, 2026, stating that the tenant needs to be out by January 9th, 2026. He never hears from the tenant and proceeds to file his eviction on January 12th, 2026. So I put a lot of red herrings in there for you guys. Who can respond back to this question? Will landlord Michael Jackson succeed at trial? I'm going to go over to the chat because somebody put the perfect answer, and I'm going to call that person out. Let's see really quick. All right. So Shane Trevino said the correct comment. He will not succeed. There needs to be a mutual agreement. So, and Shannon Knight as well. No lease addendum allowing email notices is required. So in order for him to have prevailed, he needed to put in his lease contract that he is allowed to send the tenant notices via email. If not, if this is not in writing within your lease contract and both parties have not agreed, then the case is going to end up getting dismissed. So it's going to be very important that you guys are looking out. If you got a Texas Apartment Association lease, it's going to be in there because they're fully protected. They have excellent lease contracts. But if you do your own lease contract, which some of my clients do, some of the funds do that, you want to make sure that you have that in there and that the tenant is consenting to it and that it's on the application as well. That way you have that person's email. And it may not hurt to test out that email before you send a notice to show that you've emailed this particular tenant in the past. So make sure that you guys have that in your lease contracts. If not, you're going to result in a lot of cases being lost if you're going to be sending out these notices via email.
It sounds like landlord Michael Jackson tried to be a smooth criminal, but he was bad.
Exactly. Exactly. A little too smooth. And I'm going to speed up the process a little bit, guys, because I know that I'm taking a while. We can go to the next scenario.
Okay.
All right. Manager Susie sees Jane Doe, the tenant who is late on her rent and has been late in the past. walking away from her car in the apartment complex's parking lot. Jane Doe's car is still running, and she states that she is coming right back to move it. Instead of walking all the way to Jane Doe's unit, manager Susie decides to slip the notice to vacate onto Jane's windshield, and then she walks away. Jane Doe sees the notice, picks it up, and reads it, and then throws it on the ground. At trial, Jane Doe states at the eviction court that she received the notice improperly at her car instead of at her unit. Will manager Susie win her eviction? I'll give you guys a second to answer that question.
We're getting resounding no's.
Yeah.
All right. I'll give it another 5, 6 seconds. All right. I see my response. It disappeared really quick. Let's see. Miss Isbell said it correct. Yes, she did receive the notice. It doesn't matter how it was delivered. Mr. Michael said it correct as well. Jane Doe did receive actual notice and she admitted to it. So I say yes. That's correct. So that's going to be one of the biggest changes with SB 38 is that now it doesn't matter whether or not you use the incorrect method. What matters is whether or not it was delivered and the tenant acknowledges that. So if you're in court and you have some way to be able to show that the tenant actually received the notice, it's going to oversee or supersede any bad methods of delivery. And so even though manager Susie put it in the windshield, which is not one of the methods that are used under the property code, Jane Doe admitted that she actually had received the notice and she did it in open court. And so based on that, in this case, you would prevail. So now I wouldn't recommend doing any of these, do it the correct way, but I just wanted to let you guys know that you do have arguments that you can make when it comes to your methods of delivery. If the tenant says that, the email was bad or anything else, as long as you can show that it was actually delivered, then that works. And if that person admits to that delivery, that's even better.
Yeah. For email, should they do like read receipts so they can see where it's received and delivered and opened? Would you say that would be the best thing to do for tracking email?
So I watched another webinar and it actually said that read receipts weren't good because then the tenant can ignore it. So what matters is that it's delivered. So I wouldn't put that out in the air because all we want to do is show that it was delivered. So the best method would be just to bring your sent mailbox, showing that you actually sent it with a timestamp. That should be the best thing for you to be able to use. Just because the read receipt may allow the judge to interpret it and say, well, hey, they didn't get the notice. And some judges may, again, these are new laws. Some judges may rule against you moving forward. So that's why you want to be a little bit careful with that.
Okay. So sent items it is. Okay.
And I'm going to answer a real quick question. Would it delivered during office visit? That'll work as long as you can prove. But remember, when you get to court, it's going to be your word against that tenant's. So that may not be the best method that you want to use.
Hopefully they have CCTV in their office.
Exactly.
Yeah.
All right. Is this the same one? Is this a new one?
Let me see.
Yep.
This is a different one. Manager Susie sees Jane Doe, the tenant who was late on her rent and has been late in the past, walking away from her car in the apartment complex's parking lot. Jane Doe's car is still running and she states that she is coming back. So basically the same set of facts, but Jane Doe does not appear at the eviction. Will manager Susie win her eviction? All right. Let me get some responses really quick.
Looks like we're getting a lot of yeses.
Yeah. So somebody brought up a good point because I didn't even think this all the way through whenever I made the scenario. So yes, by default, because the tenant didn't show up, then yes, at that point you would win because the tenant didn't show up. But let me change the scenario up a little bit more and I'll let you guys answer again. What if she has an advocate that can advocate on her behalf that shows up to court and it's not a default judgment? Will manager Susie win her eviction in that case?
Now it's kind of a mixed bag.
Yeah. So, all right, guys, on this one, you wouldn't win your case because if there's no way for you to be able to prove that she actually received the notice, then you're not going to end up winning. She has to actually admit that she actually received the notice. That's the only way that you're going to prevail in this instance, because then you use the incorrect method of delivery on this particular case. You needed to use one of the methods that we discussed earlier. So this is going to be a no on this particular set of facts, guys. All right, we can move on to the next slide.
All right.
All right, somebody brought up a good question. If it was caught by an outside security camera, if you got her actually delivering a notice, it's going to be a sticky one on that one. So bring that question up whenever we go through the Q&A. All right, guys. So this is one of the biggest issues that we're going to discuss today is in regard to the CARES Act and the way that they're going to apply the new law. So prior to SB 38, properties were required to deliver a 30-day notice if they had certain loans, which are going to be through Fannie Mae, and Freddie Mac. So you were required to deliver a 30-day notice for that, as well as if you were a tax credit property, a HUD property, which means Section 8 voucher-based property, or a project-based property as well, you were required to deliver a 30-day notice to vacate. In the new SB 38, they've put out new language that will basically allow you to be able to still deliver. Well, let me start off by saying this. The CARES Act is still in place. So I don't want you guys thinking that the CARES Act is out. It's still in place. In Texas, we can't overturn federal law. The only people that can do that is going to be the bigwigs who are up in Congress. They can make the decision to override the CARES Act or rewrite the CARES Act so that it no longer requires a 30-day notice. But what Texas has done in this instance is kind of circumvent that particular law because there is a small gap in the language, which we believe, or the law writers believe, is gonna allow you to be able to basically deliver a 3-day notice to vacate moving forward, as long as after the 3-day notice to vacate, it takes at least 30 days for the notice to for the writ of possession to be executed. Because technically, under the CARES Act, that's what the law states. And so I'm giving you guys this advice, but I want you guys to know that, as I stated earlier, there's over 800 to 900 judges in this particular state. They are all going to have different views of how this particular law should be imposed on your notices. They're all going to read into it different. They all come from different political backgrounds. They all have their different stances just because they're all going to be human beings and they're all going to have different ways that they interpret this particular law. But with the what's the word I'm looking for? With the intention of SB 38 was to allow you guys to be able to deliver these 3-day notice to vacates instead of the 30-day notice to vacate. Again, as long as the writ of possession is not served until at least 30 days after delivering the notice to vacate. And I know there's going to be a lot of questions, so I'm going to say more of that during the Q&A. What we have to remember, though, is that there are still some properties that are going to be covered by HUD. If you're covered by HUD, you're still going to be required to go by their particular 30-day notices just because their particular requirements are outside of the CARES Act. The HUD requirement for project-based property still requires you to deliver a 30-day notice prior to your eviction. So you want to make sure that you're still complying with that when it comes to HUD properties, mainly my project-based and voucher-based properties as well. Any other properties that are conventional, or if you're a property who was required to deliver a notice to vacate based on the fact that you had a Fannie Mae loan or Freddie Mac loan, I would roll this out a little bit and see how the judges kind of fill out your judge. And then within the first quarter of the year, you can make a decision on whether or not you're going to move on to just delivering 3-day notice to vacates. So wait until you see whether or not the judges are going to be dismissing your cases before you just go ahead and go all in on the 3-day notices, unless your management company tells you what to do. So I just want to make sure that that's clear, that I'm not telling you guys in this instance to stop delivering 30-day notices. I'm just telling you what the interpretation is and what the intent was behind the new legislation that they're going to be putting out. I recommend that all of you guys speak with your attorneys for your individual management companies. That way you can figure out how your property management company is going to do it moving forward. All right, so this is in regard, again, to SB 38 and the fact that it establishes an enforceable detainer suit against a tenant whose right of possession is terminated based on non-payment of rent. The written notice to vacate given to a tenant before the filing of such a suit must be given in the form of either a notice to pay rent or vacate, or a notice to vacate. In addition, if a federal law or rule requires a landlord to give notice to a tenant before the landlord requires a tenant to vacate the premises, the following apply. 1, a landlord that satisfies the notice requirement is not required to delay the filing of an eviction suit based on the federal requirement. So that's the actual language that came out of the SB 38. And so again, it's open to interpretation, because basically what it's saying is that if the CARES Act or this particular federal law is requiring you to deliver a 30-day notice to vacate, it doesn't delay the actual filing of the eviction, which allows you to be able to deliver a 3-day notice to vacate and then file, as long as, again, that writ of possession is not served on the tenant until the period between the delivery of the notice and the service of the writ equals or exceeds the period prescribed by the federal requirement, which is 30 days. The federal requirement is not a basis for a court to delay or abate the conduct of the eviction suit. The way that they put them into play is to kind of circumvent that particular 30-day notice requirement that's in federal law. But again, the CARES Act is still in place, guys. So please remember that. And so we anticipate that legal aid and pro bono attorneys are going to get up there and they're going to say, well, this interpretation doesn't make any sense because federal rules require you to deliver a 30-day notice to vacate. So again, it's going to be on the individual judges who are going to make the decisions on how they're going to apply the law. In that first quarter, once they kind of are on the same page, then we'll see a little bit more case law that'll make a determination on whether or not you guys will be good on just delivering the 3-day notice of vacate. Okay,
Yeah,
we
it
can
would be
move forward.
nice if the law was clear.
Yeah, and it is pretty clear. I just don't want to get up here and say that this is not, that this is going to be the ironclad law because I know
Sure.
I got a bunch of judges that we go in front of and they all have different opinions. So I got a feeling that, there are going to be some cases that we end up losing. There are going to be some cases that we're going to end up winning. But until what we call case law, which kind of like
Says the
that's when the
same.
cases move up the process and the Supreme Court gets around to making a decision on it. Until that happens, it's going to be the Wild West in regard to this particular CARES Act notice requirement.
Yeah, and just to jump in here real quick, we will still be having the CARES Act on the file eviction page. I know a lot of our properties see that and they don't want to answer it or they don't want to answer it wrong, but when filing eviction, you're just going to have to fill it out to the best of your knowledge. If you've served a 30-day, if you have not, whether or not you believe that the 30-day notice to vacate is still required. So we won't be removing that. I've had a couple of people request that we remove it from the file eviction page, but as of right now, we're going to keep the CARES Act information on there.
Yeah, and somebody brought up a good point. So the FHFA, which is basically all of those loans that came through Fannie Mae and Freddie Mac, they've eliminated their requirement, but that's on the duty of the ownership. But please keep in mind that the CARES Act is still in place on a federal level. So some of you guys will just need to be careful with your judges. It's excellent that some of the judges have already started accepting 3 days, and I got a feeling that's going to be across the board. The only county that I'm worried about is Travis County. So if you're in Travis County, that's whenever I'm going to be a little bit worried about you. But Harris, Dallas, Bexar County, kind of. But Bexar and Travis, be careful with your judges out there in regard to this particular 30-day notice.
Yeah, we actually had someone write in. Sean Shannon said Travis County is going to be very interesting going forward. So
Yeah.
sounds like you guys know what's going on in Travis County. So just a time check, Jake. We've got about 10 minutes.
Okay.
So if we want to get to
Yeah.
Q&A, so yep. Okay.
Okay, that works.
Yep. You want
Let me
to
see. Go through really quick. Let me just make sure that there's nothing important that I could cross in a minute. I know I took too much time. Okay, I'm gonna go over this really quick, guys, because I know that we're starting to run out of time. So again, as I stated, the process for these particular writs and your citations will be very quick. So if the constables are taking over 5 days to be able to serve the citations and the writs, at that point, you can go out and hire a qualified law enforcement officer, but they have to have a certain training. And there's also going to be a particular citation that's going to be issued from the courts that's going to allow you to be able to get that served by this particular off-duty officer if you need to speed up the process. If your constables are taking 10, 15 days to be able to serve these documents, it may be good to have somebody's contact in your phone that's an off-duty officer that can serve these things quicker, especially if there are tenants that are, creating violence or issues on the properties. That's when this is going to come into play a lot for you guys.
Yeah.
And this is just my guideline for you guys rolling it out. This is just my advice. You guys don't have to take it. Different management companies will balance the risk a little bit more, but my guidelines are to go ahead and split all of your eviction cases on a 50-50 basis. Do it the old way on 50% of your cases, and then do it the new way on the other 50% of your cases. And then if you see your cases getting thrown out in regard to one of the methods, then that means that you either need to go back to the old method or you need to go back to the new method, or allow us to be able to make arguments on it so that we can see what the appeals courts are going to do in regards to these particular cases. So just make sure you read over the slide whenever you get an opportunity. That way you understand how I would roll out this process in each one of the properties.
Yeah, ease into it sounds like.
Exactly.
There's another scenario, but do you want to skip this so we
Yeah,
can?
we can skip that scenario. Yeah.
And
This
it's
is summary disposition. It's basically for squatters. They've introduced a summary disposition that allows you to be able to get squatters out a lot quicker. We discussed it earlier. Just make sure that you read over the note in particular because there must be no lease or agreement in place. And I would always advise that you get a legal consultation.
yeah.
This is just a timeline that we discussed earlier. 21 days is whenever the JP and County Court eviction trials must occur within 21 days of filing or appeal. Appeals must be heard within 21 days of the transcript reaching the court.
Okay.
And then this is just in regard to the tenants who have to pay into the court registry. Remember that you can get a writ of possession either on the JP level, but now you can also get a writ of possession on the county level. Another good thing that they introduced to SB 38 is that regardless of the case, the tenant still has to pay rent into the court registry. Previously, if you evicted on a lease violation or it was a non-monetary eviction, the tenant didn't have to pay into the court registry in order to appeal the case. Moving forward, they will need to pay into the court registry, which allows you to be able to get rid of possessions a lot quicker in the event that they fail to pay that rent.
Okay.
And then this is exactly what I talked to you guys about. Some of the courts that you have, especially like in Harris County and Travis County, they may require you to do some type of mediation process or pretrial discovery and all of this. This is going to stop the process of the court of those JP judges requiring you to do this before moving forward on your eviction. It just doesn't make any sense. The tenant's already behind 2 months. The last thing that you want to do is go in and try to negotiate something with a tenant who's already defaulted on their lease contract. And so SB 38 has prohibited the judges from making this a mandatory procedure. It's still optional, but making it mandatory, SB 38 has stopped that.
All right, now I think we're at the point to where everybody wanted to get to. So Heather and Duke, both of you guys ready? So the questions have been coming in the whole time, and they're still coming through. Do we want to divide and conquer? Let me see. Yes, we will be sending out the slide deck. What about Montgomery County? I'm not really sure what about it. It sounds lovely. So this is a statewide bill. So the entire state will be affected. Someone did so good point since we're presenting today. Just to make sure for the month of December, we will still deliver 30 days as regular and start the 3 days in January 1. That's from Vanessa.
Okay.
So
Let me see. I'm
that
trying
is
to think about what's
that
the
is
most.
true. The bill
Yeah.
starts January 1st, right?
Yeah,
Yeah.
correct. Because
So
we
the
have the
Q&A
chat and then the Q&A window. I was trying to.
So
Wait a minute.
hold up on the questions, guys, because so are we going to answer the questions in the Q&A or are we going to answer them in the chat?
We got both. So whichever one's easiest for you to do, because I bet some of them are going to be crossover. So yeah.
Yeah.
Yeah. You want to do the Q&A, Heather? Since
Yeah,
they're staying in the same place, the questions are moving up, so it's hard to read.
Yeah,
Yeah.
it is hard.
So there's 45 in the Q&A right now. So Heather, you want to answer those via typing and then I'll read out for Duke. Do you want me to read you the questions in the chat?
Yeah, I can type some answers in the question and answer box and y'all can go over the chat.
Okay.
That
all right.
works.
So what about the pauper's affidavit?
Okay, so a pauper's affidavit is just another name. They don't use that name anymore. It's called an inability to pay. And so that's the appeal process that we were discussing earlier, which requires a tenant to pay into the court registry. So if the tenant appeals their eviction and it's for non-payment of rent or for a non-delinquency breach, they're typically required not only to fill out this particular oath, but they also are required to pay into the court registry within a certain amount of time. If they fail to pay into the court registry during that time, then you're automatically entitled to a writ of possession. SB 38 has taken it a step further. And so let's say that your appeal gets sent up, the tenant pays into the court registry 1 month, but then your appeal gets sent up and it's taken 2 or 3 months for the appeal to go through. Anytime during that pauper's affidavit appeal, if the tenant fails to pay into the court registry, you'd be allowed to be able to get a writ of possession automatically, the same way that you would on the justice of peace. Previously, you had to file what is called a motion for immediate writ of possession. You had to hire an attorney and you had to go through the process of having a hearing on it. And then the judge would make a decision on whether or not the immediate writ would get issued. Now, SB 38 has advanced that to where you just file your writ of possession along with documentation showing that the tenant failed to pay into the court registry, and they're required to issue that writ of possession. Now, I'm going to say this with a caveat just because we don't know how this is going to work because this SB 38 has introduced a lot of new processes. And so it's going to take a while for our learning curve for the county courts to be able to learn how to process these writ of possessions. and to kind of dictate what is going to be sufficient proof that the tenant has failed to pay into the court registry, as well as deadlines as well. And so we'll know a little bit more about this going into the first quarter of the year on how they're going to do that. I wish that the law was, black and white, but when it comes down to new law, we got to wait for the courts to see how they're going to process a lot of this stuff.
Oh. Learning in action, right? Or emotion, right?
Exactly.
So we have back to one of your earlier slides about payments and keeping payment portals open. Melissa says, after the third, we require certified funds as a form of payment. Would our portals still need to remain open?
So it depends on what your notice. So on your notice to pay rent or vacate, it depends on how long that notice is going to run. But any other, you could keep your portal open or you can close it once that date for that notice to pay rent or vacate has ended. It'll be up to you guys, but you can still accept certified funds if the lease contract requires that.
Okay. If there are two lease holders on the lease and are two signatures needed, so this lease agreement is valid, and then whether it's a renewal or new move in, is it invalid to highlight the areas that require wet signatures on the leases?
Oof.
I don't know what that means.
Let me see if I see it. Let me read this question.
Sure.
If
That
there are
might be
two
a complex
leaseholders on the
one.
lease. Yeah, if there's two leaseholders on the lease, they both have to sign.
Okay.
They both need to sign. That's gonna be a binding contract. So the elements of a contract are a lot different, but you have to have an agreement and you have to have a meeting of the minds. Typically to demonstrate that you're gonna show some type of signature to show that there's an agreement. And when it comes to wet signatures, I don't typically most of my lease contracts are digitally signed. If you mean wet signatures, like actual signatures, as long as they sign in some type of way or fashion, that's going to be sufficient. But you need both to sign on the lease contract. If not, it may be more difficult in the future to impose liability against the person who failed to sign the lease contract.
Next is, what if you are not covered under the CARES Act and do a 3-day notice? Do you still have to file the writ within the 30 days?
No. So this only applies for properties that are covered by the CARES Act. If you're a conventional property, you do a 3-day notice, you'll do the same thing that you've been doing in the past.
Okay. Melissa, since we know I want to go to Travis County now. Since we know Travis County is difficult, would you advise for a tax credit property to continue to deliver a 30-day?
So I can't give you guys guideline on what you want to do. It's really ultimately going to be up to you guys. I don't want to tell you guys, hey, start delivering 3-day notice of vacates, and then your judge just happens to be one of those judges that disagrees with the interpretation of the law. So it's going to be on a case by case basis. I want to make sure that you guys look over the last slide that I have on there and test the waters with your judge first. So it really is going to be based on how much risk you want to take. If you want to try out the 3-day notice to vacate method, try it out. See how many cases get thrown out. If the cases don't get thrown out, great, move forward. But if your cases do get thrown out, then you may want to reassess that and just get with whoever your legal counsel is for your particular property management company and assess the situation from there. So I don't want to give you guys a pinned down answer on the 30-day notice of vacate because I don't want you guys to come back and say, oh, Mr. Amos told me this or Mr. Amos said this, and then your judge disagrees with the interpretation. Again, we're going to have to wait for at least the full first quarter to finish off before we know something concrete on how the judges are going to interpret this law.
So another question about late policies. Does the first time late policy reset for every lease term, or does it just apply to the first time that they are late for the entire residency? From Amber.
So that's a good question. To be safe, because technically when a lease contract ends, a new one begins, new terms begin. And so my interpretation, and I think that the way that a lot of judges are going to interpret it, is that they need to have been late within that particular lease contract. So if they have 2 or 3 lease contracts and they've been late on the one that they signed back in 2023, it's probably going to be a safer bet to deliver a notice and then they become late on their most recent lease contract. It's going to be a lot safer for you to deliver a notice to pay rent or vacate. So I would say within the particular lease contract, if they're late within that for the first time, just be safe and deliver a notice to pay rent or vacate.
Another Danny says, how do you find out if your property is bound to HUD laws?
So there's various websites. I want to say Nationwide has Heather, do you guys still have that link that allows them to be able to search?
Yes, it's still up on the file eviction page. There are a few little links that people can use to search and see if they're under HUD.
Okay. And you guys can find that on our nationwide homepage at nationwidecompliant.com. Heather, since we have you, this is a
Mhm.
nationwide question.
Yeah.
Can the email be uploaded into Nationwide showing that it was delivered?
Yeah. Yeah.
Yep.
Any proof is better than none. So upload whatever you have as long as it's in a
Photos,
PDF
right?
format.
Yeah.
Yeah. Yeah. Our
Yeah.
system won't accept it if it's not in the PDF format. So a lot of
Can they
people just
also,
use like online conversion tools for that if they need help
oh,
with
sure.
it.
Yeah, can they also upload the photos of like delivery?
Yeah, they can upload the photos as long again as it's in a PDF format.
Yeah, yeah. So, guys, it sounds like Nationwide will help you guys with this law to stay compliant. So, with some of those scenarios that Duke mentioned earlier. Uh,
Somebody asked a good question. Let me answer this question.
sure,
Can I
sure.
still post a notice outside the door, affix it outside the door, and then mail it if I can't get in the apartment or if I don't feel safe? So that's a really good question. That's not so they cut that particular method out of the property code. That's no longer going to be a valid method of delivery. And so I'm interested to see how the courts are going to basically allow you guys to deliver notices if you can't get on the unit, because if you can't get inside of the unit or you can't get in contact with the person, because we all know that a lot of the tenants, they'll double bolt the doors to where you can't get in, or they have an animal inside of the unit. And so the best method for that may be to do it via email, or for you to be able to do it via mail. Using certified and first class mail would be my best method for you guys.
If we serve a NTV with current form in December for a first-time delinquent person, but the eviction filing will be in January, will the old form work in January, or do we need to start using the new form based upon calculation of when the eviction filing will be? We are
It
cares.
depends. Yeah, it depends on when you're going to file that particular eviction. So if that eviction is going to be filed in January of 2026, I don't think, to be honest with you, I think Blue Moon took all of the old notices off. So there was another webinar, and they basically stated to start using the new notices in Blue Moon now if you're going to be filing in January, but it has to be filed in January. If not, then those new regulations won't come into play, and you may end up getting your case dismissed.
And then one, it sounds like we're getting excited about email options. So for pre-existing residents, can we create an addendum for them to sign in to opt in to email notices, or do we need to wait until renewal?
If there's a way that you can get them to sign off on anything, it just needs to be an agreement in writing. It doesn't say that it has to be within your lease contract. I'm sorry, it doesn't say that it has to be at the time of renewal. If you want to get them or try to get them mid-lease, which maybe it's probably going to be very difficult to do, but if you can get them to sign some type of addendum and it's in writing and that both parties have agreed, then you'll be good going into 2026 using that email method.
Um, do weekends and holidays count? Someone wanted a clarification about the NTV days.
Yes. So moving forward, Saturdays and Sundays are going to count. So it's going to bump, like if the deadline is on that day for you to file or your notice to pay rent or vacate, it's going to bump it to the following business day. So it'll be the Monday. And when I say the Monday, that's the day that it expires. So that means that you got to file on the Tuesday. So just make sure that you're accounting for those numbers. But again, the Texas Apartment Association lease, I want to say that they're going to introduce some language that's going to allow you to be able to oversee or supersede that.
I'm not sure what this one is. If we split the type of notices, is that fair housing?
I don't think I understand that question.
Okay. Lindsay, we're not really sure what you mean. If you want to write back in and explain a little bit, we'll try to get back to you. Can we
So
slide it inside the door? I thought that was
I was, yeah, I
I
was just
thought that
about to
was the
answer
no.
that. Yeah, that was the question that I wanted to answer. No, you cannot slide it through the door, guys. They made it more than easy for you guys now. So you can slide it through the door. I know that a lot of you guys like to do that because it's a lot to get the keys and open up the door if the tenant doesn't answer. But please don't do this, because cases are going to get thrown out or dismissed if you're still doing this, just because they made it so easy for you to deliver the notices now.
Okay.
Any Blue Moon questions, guys? I can't address that. You're gonna have to, in the Texas Apartment Association, they have a webinar as well. So they'll address some of those Blue Moon issues if you want to talk with them.
Vanessa helped out a little bit. She said she thinks Lindsay means the 50-50 method that you're saying. So if they do 53 days and they still do 50 the old way with the 30 days, is that still fair? How is it still compliant?
That's a good question. As long as you're not doing it based on any type of like race or anything like that, then you should be okay with fair housing. As long as there's an explanation for why you're doing it and it doesn't discriminate and it's at random, you should be okay on why you file on those reasons. But if you want to break it up a little bit more and try 1 month doing the 3 days, all of them, and then the following month doing the 30 days, that'll be up to you guys as well.
And then a couple of questions, and this will be, I think, most of them. Any others we'll keep answering, and we'll follow up with you. But they're asking about now the ability to get like off-duty licensed officers or guards. What are their qualifications? So I don't
So
know
there's
if
gonna
I'm
be a training program that comes out for these particular officers. So the criteria, what I'll do is I may have to update the PowerPoint because there's a particular criteria that they're going to require for these officers. But they basically have to be trained through a certain program in order for them to qualify to be able to deliver notices.
that makes sense. Can we still choose to use the notice to pay or vacate for habitual late payers?
Yes, that'll be optional for you guys. As long as it's not their first time being late, that's when it's mandated. But if they're habitual payment, you can either use the notice to vacate or the notice to pay or vacate in those situations.
And Luz, yes, this starts 1/1. That's when the bill goes into effect. What if we do 3 days for the higher balances and 30 days for the lower balances? Would that be against fair housing?
I would do it at random if you're going to do it. I wouldn't use any type of criteria
Yeah.
if you're going to do it at that method. And it may be safer just to file just a few evictions all across the board using one method and then see what your feedback is. Maybe if you got 10 delinquencies, file 5 of them, see what happens, and then you can make the decision to file more. I know that's not the best idea because it's going to take at least a month for those cases to be heard, if not a little bit longer than that. But just make sure that you're not using any type of particular criteria on how you're selecting the notices that you're going to do 3 days versus 30 days.
So this is kind of a good one for clarity. This new law, will it affect new leases only or prior leases?
So the law has nothing to do like it's going to affect all leases. So it doesn't matter if it's an old lease or a new lease. But some of the things that are in the new lease are going to be required through SB 38. So you want to make sure, for example, if you're using a lease from 2024 in the email process, I want to say that it already has that language in there, but you want to go back with your legal counsel and make sure that all of that language is inside of those notices.
All right. I think we're starting to slow down and we're already past time, guys. Let me move this because I know, Heather, you had a little something to share with us. Duke's been taking all the spotlight. So, Heather, being from Nationwide Compliant, we heard a few tips and tricks that you mentioned along the way, especially about the software with documentation, which seems to be one of the biggest parts of this SB 38, and then like, capturing with the photos or uploading proofs and proof of delivery, which Duke is made sure that's the main thing is you have to prove that the notice was delivered and then wait the appropriate time before you file an act. So can you tell us a little bit about how Nationwide helps with that, Heather?
Yeah, so you'll be able to upload any of the photos or like your outbox of your emails to your tenant form, same place that you uploaded the lease, notice to vacate, ledger, that kind of thing. And I think that there's probably going to be like a lot of questions coming in January on the notice to vacates, and rightfully so. It is kind of confusing with the notice to pay rent and the notice to vacate.
Sure.
So I think that you'll be able to have the legal question for Duke. We send that over to him and he'll be helpful, I think, a lot in January for that. But he is our in-network attorney and he does a great job at handling all of our appeals and bankruptcies and higher escalated things that we have going on at Nationwide. And our goal really is to help property managers have their managers on site to help with operations and seeing everything day to day. So we really strive to have our agents in court, and the more information that you upload for our agents on the day of hearing is the better that we're going to be able to represent you. So as Duke suggested earlier, taking photos, your outbox that you've sent emails. And I know a lot of questions came in, like what if they change their email? And I don't know that, Duke, do you have any advice there? Like if they change their email mid-lease, like what are they supposed to do if they don't know that they changed their email?
So if it's a Texas Apartment Association lease, there's going to be a clause in there that requires that if they decide to update their email, they have to give it to you in writing.
Okay.
There we go.
Yeah. And then just besides proof of delivery, like what else does Nationwide help with for processing lease compliance that is helpful to all these guys on call today?
Yeah, so we really review your notice to vacate and make sure that you sent a signed notice to vacate. Duke mentioned it earlier in the webinar, but like one of our biggest things we see for cases being dismissed is notice to vacate related issues. That's, I think, our number one reason for dismissed cases. So with these changes, there is going to come confusion, but follow these guidelines that Duke's given to you, follow the guidelines that TAA has set out for you, and make sure you're using the most up-to-date rules. Check with your legal counsel and all of that to make sure that you're giving them the best notice and make sure that you have proof of it. Because I think the emails are going to be a big argument, especially for counsel for the defendants. So you want to make sure that you do things the right way.
Right. And then you can track and keep updated and get communications through the software. So you guys can be on your properties and not in court or tracking down something from the county clerks. So there's a lot of tools and helpful information. And then Heather, you guys even offer free training with Nationwide, right?
We do. We have a new user training that our support team does a great job at heading up that walks property managers through how to file your case, how to review your court date time, what the result is if you get a reset, how we communicate with you. We just do attorney notes, and I'm going to go ahead and throw it out there because this is another issue that we have a lot of times is that property management companies don't update their email address in our system. So we're sending all these really time sensitive emails that we need a response to, and you guys aren't getting them because your email is not updated. So if you don't know how to update your email in the system, you can email our support team at support@nationwidecompliant.com. Make sure your information is updated because that is where all of the time sensitive information that we send to you is going to come through email 99% of the time. So make sure that is updated for sure. That's a big one. That's a big communication gap that we do have is through email. So
It sounds like we're going to be having one on the renter side too, because if
yeah,
we change theirs, so
yeah.
everybody
Mhm.
notify everybody when you change your email address. So
Yes, for sure. And then we just provide end-to-end case management with our agents appearing in court for you and on-site team able to stay in office.
yeah, that's great. So, guys, reach out to Nationwide Compliant. You can email or visit the webpage, email support@nationwidecompliant.com if you want more information or set up for a free demo or consultation. The website, which Heather told you guys, there's some forms there. One of the questions was about how to see if you're on HUD or bound to HUD guidelines. That's listed there. We have a toll-free number. And also our fabulous guest, Duke, today, who has, as you can tell, much more knowledge than we even went over. So much more knowledge to offer. You can reach him. He has the Amos Law Firm, which he presides over, and his number on screen, 281-994-7210, and then his email below, damos@theamoslawfirm.com. And he is willing to help and stand by. He's very, as you can tell, knowledgeable and passionate about multifamily, the industry and the laws that revolve around it. And then he is up to speed, which is why he is our expert speaker on SB 38. So guys, we thank you so much. We know questions are still coming in. We have compiled them and we'll continue to answer them and we'll post them in an FAQ. Please expect about 24 hours. There should be an email with the replay, which will have all this information on it coming to you. And if you have any more further questions, we'll be glad to take them for you, redirect them to Heather and her team, and then they can also contact you. There will be a quick 5-question survey at the end. One will be, would you like to be contacted? And then also, if you have any other questions to add too, you'll have the ability to complete that at the close of this webinar. And with that, Duke, we thank you so much. Heather, thank you so much for answering all those questions. I saw you typing fast and furiously. And thanks everyone for joining us today.
All right, guys, have a good afternoon. I wish that we could answer more of the questions because I see a lot of questions coming through.
Yeah.
So I wish that we could answer more of them, but I'm assuming maybe they may host another webinar later on next year, maybe.
I think so. I think we may be doing
Okay.
an SB 38 follow-up.
Okay.
There might be
I would like that. Yeah.
All right, that'd be great. Well, thanks everyone. Have a great weekend and we'll see you soon.
Thanks, guys.
Thank you.